guest speaker today is Kieran Pender. Kieran is Senior Legal Advisor with the International Bar Association's Legal Policy and Research Unit in London and Visiting Fellow at the ANU Centre for International and Public Law. He leads the IBA's efforts to promote diversity and inclusion in the law and authored the landmark 2019 report Us Too. We will actually send you a copy of that when we send the summary out after the presentation. He's a good friend to BAL Lawyers and a colleague. Welcome, Kieran, and thank you for joining us today.
Thanks, Rachel, and thanks to everyone joining us this morning. And for those worried, for me, I'm in Australia rather than in London at the moment. I got stuck here during COVID, so it's thankfully 8 a.m. rather than 11 p.m. at night for me. I'll just share my screen and we'll get underway. And as Rachel said, please send through any questions or comments. We'd really love to hear your thoughts and experiences in this area. So as Rachel mentioned, for the last 3 years, I've been working with the International Bar Association, leading our work, particularly to address bullying and sexual harassment in the legal profession. And so today, I'm going to begin by giving a bit of context to the sort of this area in Australian law and workplace relations, look at some more recent Australian developments with a particular focus on the Human Rights Commission's landmark recent report. Then I'm going to discuss briefly our work in the legal profession and then sort of focus on some of the insights, trends and best practice that we've seen coming out through that, which I hope will have really practical application for you and your workplaces. And then, as I said, would love to hear your thoughts and ideas and questions. Now, if you'll forgive me a very brief history lesson, the reason I think it's important to begin with the context is I think it's important to see where we've come from and the development that we've had so far, but also the continuing development we need. You know, we've been working to address sexual harassment in workplaces for over 50 years now. Obviously, we've made some progress, but as the recent reporting about high-profile cases has indicated, we haven't made enough progress. You know, the term sexual harassment was coined in the 1970s. Obviously, it was happening before then, but that was the first time it was given a name. And that coincided with a number of Australian states introducing anti-discrimination laws. In 1983, Australia ratified the Convention on the Elimination of All Forms of Discrimination Against Women at an international level, which gave impetus to more national work on this. And the Australian government began to think about a Sex Discrimination Act. Now, that timing was in a way fortuitous because it coincided with a really important case under New South Wales anti-discrimination law called O'Callaghan and Loader, where a senior member of staff at a New South Wales government organisation quite significantly sexually harassed a very junior member of staff, very graphic, very disgusting conduct. She sued him for sex discrimination. And the tribunal said that workplace sexual harassment could constitute sex discrimination, but that wasn't enough. And there needed to be some additional blameworthy feature, such as sort of power imbalance. And although there was in this case, the tribunal said that because she had not made it very overtly clear that she was uncomfortable by his actions, it wasn't sex discrimination. Now, you know, that generated a lot of outrage at the time, as you'd expect by such a decision, and that then fed into the development of the Sex Discrimination Act, which still is with us today, and particularly the decision to have a standalone sexual harassment prohibition. So on one hand, we can look at sexual harassment as a form of sex discrimination, but the Sex Discrimination Act went one step further and said we're going to have a specific prohibition. Although the law has changed slightly in the ensuing decades, it's sort of been fairly consistent in this regard, other than a few minor changes. And that is sexual harassment is if a person makes an unwelcome sexual advance or sexual request or otherwise engages in unwelcome conduct of a sexual nature, and in the circumstances, a reasonable person having regard to all of those circumstances would have anticipated the possibility that the person harassed would be offended, humiliated, or intimidated. So, there's some definitional thresholds to satisfy, but broadly speaking, quite an inclusive, broad definition of the terms of conduct that fall within this. The Act then, most relevantly for our purposes, said that it was unlawful to sexually harass an employee, someone else, someone seeking employment, or any other workplace participant. So again, broad definition that anyone in the workplace sexually harassing each other, whatever the exact form of employment, contractor, volunteer, etc., whatever the power imbalance between them, that's sexual harassment. And that's important because in a number of other jurisdictions, sexual harassment has to have a power imbalance. So if two co-workers, in Singapore, I think, two co-workers sexually harassing each other doesn't constitute unlawful sexual harassment under the Act, whereas in Australia it does. And obviously it's for employers, sexual harassment occurring is not okay at a moral, ethical, and level. But particularly the Sex Discrimination Act also made it unlawful because it imposed vicarious liability on employers. So, if an employer doesn't take all reasonable steps to prevent sexual harassment occurring, then the employer is vicariously liable for the acts of the employee. So, this is really the most critical element of the law that means that employers are really obligated to take steps and act proactively to prevent sexual harassment occurring, or else they'll face legal and financial risk. Now, just two more elements of the law before I turn to more recent Australian developments. Significant cases that have really in the last 2 decades expanded the Act and therefore expanded employer liability. And the first of which is a case called Lee and Smith in the Federal Magistrates Court, as it then was. That involved employees of a Commonwealth department who had work-related drinks that had gone back to someone's residence for a work-related dinner party, and subsequently there was a sexual assault took place. And the target of that conduct sued the Commonwealth, among others, for that incident. And despite the fact that there was quite a distance between the direct workplace and the incident, the federal magistrate kindly said that the nexus with the workplace was not broken. So it gave a very broad interpretation, which has been upheld and continued to be applied in terms of out of hours conduct still falling within the scope of the Sex Discrimination Act and therefore still capturing employer liability. The other and most significant decision in sexual harassment litigation, arguably of the last 40 years, is a case called Richardson and Oracle. And you might have heard of this in 2014. And before this case, damages in sexual harassment cases for non-economic loss, so pain and suffering, embarrassment, humiliation, what are called general damages, they had hovered in a range between $10,000 and $20,000. Now, there were some really egregious cases of sexual assault where higher amounts were awarded, but generally speaking, the amounts were in that range, and that was really inadequate. And given that to run sexual harassment litigation, if you're a plaintiff, to conclusion, it costs hundreds of thousands of dollars potentially. Even if you win and get your costs there's a high chance you'll still be out of pocket whatever is awarded. So, that was the state of the law. That was unsatisfactory from a plaintiff perspective. Ms. Richardson worked at Oracle and was sexually harassed by a colleague. She sued Oracle and the colleague and was awarded $18,000 in general damages. Because her legal fees were so high, and particularly because the other party, Oracle, had made an offer to settle on more advantageous terms, and so therefore, due to cost rules, she had to pay a large amount of their legal fees for rejecting that offer. So, despite the fact she'd been vindicated in court, she faced financial ruin for seeking to, prosecute her rights not to be sexually harassed and seek redress, for what she'd suffered. So she appealed. And the full federal court said, 18,000 is just manifestly inadequate to represent what, people experience when they are victims or targets of sexual harassment, and said that the community expectations have shifted. And so they increased the award of damages to 100,000. Now that trend has been continued and upheld quite explicitly in the subsequent years. So, what that means for employers is that the financial liability of sex discrimination, sexual harassment litigation has increased significantly. And this is only also general damages. It doesn't necessarily include economic loss that might be suffered. So, that happened, and I guess that began more consideration and discussion by employers and in society at large of these issues. But as we all know, the biggest source of impetus for this area has been the Me Too movement, beginning with the New York Times and the New Yorker's reporting of Harvey Weinstein and everything that has followed. If we move now to some developments in Australia in the last few years, I guess the first point to make is that this is a problem in our workplaces, and there's extensive empirical evidence for that. The Australian Human Rights Commission has regularly undertaken national surveys. The most recent one in 2018 was 10,000 Australians using a representative sample, so fairly robust evidence. And it found that, just in the last 12 months prior to the survey, 1 in 5 women, 16% of men had experienced sexual harassment. If you expand that to the past 5 years, the numbers increased significantly. So very much a challenge for Australian workplaces to be proactively addressing these issues. The Human Rights Commission was working away and had published a report on these issues that came out in March, just as COVID hit, unfortunately. That was working away, but their work, and I was actually speaking to the Sex Discrimination Commissioner just the other day, Kate Jenkins, she was saying that their work has really been given momentum and impetus by 2 stories that have followed, in the Me Too vein. And the first of those is obviously the Dyson Hayden, former High Court judge, sexually harassed his associates, number of them. And secondly, the AMP case, which has been playing out in the financial press for what felt like a month. 2 very high-profile cases that really pushed further, and I suspect will lead to more momentum and impetus for changes that the Human Rights Commission has recommended in its report being made into law. So to touch briefly on those, and particularly because they'll likely have a significant impact on employers, Kate Jenkins and her team published this report, as I mentioned, in March. A long read. It's almost 1,000 pages, has 55 recommendations. But the crux of it was, workplace sexual harassment is a problem, and collectively and individually, we need to do more. As her foreword said, the current legal and regulatory system is simply no longer fit for purpose. Probably the most significant of her recommendations from an employer workplace perspective is the recommendation to amend the Sex Discrimination Act to impose a positive duty on employers to take steps to address sex discrimination and sexual harassment. That would go significantly further than the existing reasonable steps defence to sexual harassment, because that is a defence in case of litigation. This would be a positive duty to act, and recommendation 18 is that the Commission be given compliance and enforcement powers. That would be a really landmark shift, and would come with considerable burden in terms of employers taking steps. We can touch later on what sort of steps they may be. She also recommended a number of changes to the Sex Discrimination Act. Probably most significantly from an employer perspective is a cost protection. So at the moment, sex discrimination litigation is on an ordinary costs basis, which means if the employee loses, they can, or the former employee or a current employee, they can be on the hook for the employer's costs of the litigation. Now, under the Fair Work Act, as probably many of you know, there are cost protections for both parties, so that it's no costs, which has upsides and has downsides, and they've recommended the same cost protection be inserted. What that means for employers is the potential that in defending claims that they do not consider genuine, there could be scope for considerable financial burden in that regard. They've also recommended a number of changes to the Fair Work system, probably the most significant of which is a Stop Sexual Harassment Order. Many of you would be aware of the Stop Bullying Order, which I'm sure we've probably had HR breakfast clubs on before. They've recommended sort of mirroring that system with a Stop Sexual Harassment Order. Again, would give rise to potential litigation. And they've also suggested inserting sexual harassment in various ways to make it clearer that it's a valid reason. And so I guess while a number of these things pose risks to employers, that would be one thing that makes it a lot easier for employers to act decisively and confidently in case of incidents, in terms of terminating potential perpetrators, that they would have additional protection from unfair dismissal. They've also recommended a number of reporting requirements for entities that are covered by the Workplace Gender Equality Act, for example, and/or under the ASX, which I think could really drive best practice in terms of indicators as to what positive steps look like. So there's a lot to digest there, and I'd really recommend, obviously it's a 1,000-page report, there's a lot to take in, but certainly the executive summary of the Sex Discrimination Commissioner's report is very readable and really insightful. And some of that change will come. Obviously, they're only recommendations. We haven't yet heard from the government, but from what I understand, speaking to different sources, at least some of those recommendations are going to be actioned. And so I think we're going to see a considerable shift in the regulatory landscape that governs how workplaces respond and prevent incidents of sexual harassment. So to turn now briefly to my profession, our profession, the legal profession, which as a sort of a paradigm of ethics with ethical obligations to the court and to each other, and with responsibility for advising clients such as yourselves, you might think that we'd have our house in order. Unfortunately, collectively at a global level, that's not the case. Now, the Me Too movement has given impetus to this work. However, sexual harassment has been prevalent in the legal profession long before Me Too. While I was researching the IBA report, I came across this story in the 1980s when a major American law firm held a they wanted to hold a wet t-shirt competition for their female summer interns. And they were told that's a bad idea. And instead they had a swimsuit competition. And one of the partners of the firm described the winner saying, "She has the body we'd like to see more of." Now, and that was in the 80s. At the time, that generated outcry. More recently, the Me Too movement generated outcry. We've seen, a number of high-profile incidents. I mean, I've picked 3 from Sydney, from London, from Chile. Could have picked up hundreds more. And I guess there's an interesting question about whether these issues are more prevalent in law than elsewhere. The IBA, for those who don't know, is the peak representative body for the legal profession. We're very cognizant of these challenges the profession face. We've done prior research in this area, but I think in sort of January, February of 2018, when I joined the organisation, the Me Too momentum and these high-profile incidents really gave us cause to look at this comprehensively. So we undertook what would be the largest global survey of the profession on these issues, and as those numbers indicate, the picture was pretty grim in terms of the high prevalence of bullying and sexual harassment across all parts of the law. Just a few points that I think are relevant, obviously not just to the law, but to all sectors. Targets of incidents don't report. That's the overwhelming data from our report, from other reports. And so I think when we're designing approaches and policies and reporting mechanisms, we need to be very cognizant that the cases that are reported are only the tip of the iceberg. And we need to act accordingly. Similarly, at the end of our survey, we asked everyone, regardless of their personal experiences, do you think your workplace is doing enough? Now, I've broken this down on this slide by different types of legal workplaces, but I think the takeaway, from the legal profession, and I'm sure this is not unique to the legal profession, employees don't think their workplaces are doing enough. Even in the best performing quartile segment of the profession, we saw law firms, only 1 in 3 employees thought they were doing enough. We published in May of last year this major report, some more light reading. It's only 130 pages, so a bit more digestible than Kate's 1,000-page report. And it's available online. It highlighted a number of recommendations, and the first of which was, we just need to talk about this more, and we need to break the silence that surrounds these issues. And I think in Australia we've been engaged in that task for some time now, but we are an international organisation, and there are many jurisdictions that are even further behind in terms of having open discussions about these issues. So to that end, once we published the report, we undertook an unprecedented global campaign where we visited about 30 cities around the world. We had public events, private events, roundtables. I personally went to about 25 cities during the campaign and met literally with thousands of people. And so I guess to conclude, what I wanted to talk about was what's come out of that in terms of practical insight that organisations can implement. What's the learnings that we've gathered from best practice around the world that might help your organisation. So I'll touch on those and then we'll wrap up, and would love your questions and comments. I think that the first point I would make is that no matter the size of the organisation, we can't address these issues solely through a top-down approach. Now, don't get me wrong, leadership is critically important, and it's important that leaders lead on these issues. But to drive cultural change in an organisation, you need to have everyone involved, and cultural change doesn't come from memos from the top. And to me, that was really highlighted by two divergent examples that I witnessed during our campaign. I spoke with a law firm in New Zealand. New Zealand had a major sexual harassment scandal in the legal profession in 2018. It's forced the whole profession to do a lot of soul searching. And one particular firm said that the best thing they had done, and this is a firm of maybe 300 people, they had scrapped their harassment policy and they started again. And they invited every member of the firm to contribute to that policy and to work that through and develop something that, they thought was reflective of reality and was going to work and was going to make a difference. And a committee of 10 takes a long time to do anything, let alone a committee of 300. But they said at the end of the process, it was truly transformational in terms of every single member of staff knew what was expected, what the values were they were trying to uphold, what to do if things went wrong, if there was an incident. And they all felt ownership. This wasn't just a piece of paper that sat on a shelf. This was a policy that actually had meaning. Now, conversely, I was in Paris presenting to a major international law firm's Paris office. And this is a workplace, with all the policies, procedures, training, everything you can imagine. And yet someone put up their hand at the end of my presentation and said, look, if an incident happened to me, I don't know where I'd go, what to do. I've got no idea. And that drove home to me that, the policies, the training, they're a necessary infrastructure, but they're not sufficient. And we need more than that. And we need to have everyone involved in this process of cultural change if we're truly going to empower them. You might ask why on earth I have a photo of a park on the slide. In landscape design, there's a concept called desire paths. And all of us will have witnessed this. If you go to a park, someone's paved a walkway down the middle and people have walked off to the side and created these dirt tracks that we see on the slide. And those are called desire paths. You might ask, what relevance does this have to sexual harassment? Well, we have for a long time tried to funnel people who experience incidents along the pathway for reporting that we set up and that is preferable to us. So whether that's you report to HR, you report to the General Counsel, you report to risk, you report to the CEO, whoever the reporting recipient is, we've paved these pathways and made it very clear that that's the only way to report an incident formally. That hasn't worked. And don't get me wrong, that's not to say there is not a avenue for that form of reporting, but what we've seen in our research is that people don't report sufficiently through those channels because they're not confident in them, they're worried about reprisals, they're worried about career impact, they're worried if they'll be taken seriously, etc. So I think what is emerging as best practice is having as many reporting avenues as possible. So some firms I've worked with, they'd set up, these slightly large organizations had multi-channel reporting that they trained individuals at different levels of the hierarchy of the law firm to receive reports and they were identified as such, and then they would funnel that up to the top or respond accordingly. And they said that they'd found that really effective because if you're a junior person in an organization, you're probably not going to feel confident going to someone senior to raise a complaint, particularly if it's at the less severe end of the spectrum of conduct. But you might feel a lot more empowered to speak to a peer. Similarly, we're seeing the emergence of a lot of technological solutions to these issues. I mean, I've just highlighted a number of them on the slide, but these are things that, for example, enable anonymous reporting or reporting where it only gets submitted if someone else reports against the same person. That removes sort of first mover disadvantage. And there are a number of other platforms. I'm not sort of saying one's better than the other, but I think the point is we just want to give people as many ways to speak up as possible. When we did our survey, we had hundreds of people, we had 7,000 responses, and hundreds of those responses said to us, this was the first time we told anyone, even though they were telling an inanimate survey. but that's okay. And if that is the only avenue they feel comfortable speaking up, is an anonymous avenue that may not lead to sort of decisive action, if that makes them, feel that, they've spoken up and they feel empowered, that's great. And maybe later down the track, they'll be willing to raise a more formal complaint. But giving people as many avenues as possible to speak up about incidents, I think is, really critically important. And to that end, we can't just focus on the severe end of the spectrum. Appreciate this presentation is more about sexual harassment. I've also done a lot of work on bullying. I think they're cognate issues. And for both, there's a spectrum of behaviour. And for sexual harassment, there's the severe end, and then there's sort of slightly sexual comments. There's, inappropriate pat on the back. There's things that, you're not going to go to the police over, but still make people feel uncomfortable. And we need to look at all of this conduct and address all of it. And we'll act differently. And of course, you're not going to fire someone for making an awkward comment. You might fire them for, of course, for serious sexual assault. But I think too often we hear these terms, bullying or sexual harassment, and we think of the more serious end of the spectrum of conduct, and we target our efforts and our initiatives at that. Those incidents happen, of course, but they're much rarer. The much more common form of sexual harassment is the more latent, everyday, inappropriate behaviour. And I think for too often that is sort of swept under the carpet as not sufficiently serious, and people don't report it because they think, oh well, no one's going to take a complaint about a comment seriously. But actually, we need to address all of that, because that lower level conduct often leads to more severe conduct and also has just as detrimental impact. We can't know how these things will impact people, and often an accumulation of minor incidents can have the same impact as a more significant incident. In the legal profession, which is a regulated profession, these issues are beginning to come into regulatory focus. In New South Wales and Victoria, there's a lot of focus from the regulators there on oversight of how law firms are responding to incidents of sexual harassment. That's obviously the law, but the law is not unique. And I think we're beginning to see, as we saw the recommendations in the Human Rights Commission report, additional regulatory oversight of these issues. Other regulated sectors, I know in the UK, the finance sector, there's more and more regulation around these issues there. So I think it's a good opportunity to get in early and address these issues before we are collectively forced to by regulation. Just a couple more points and then I'll wrap up. There has been a backlash to the Me Too movement. And I saw that. As I said, I traveled the world in 2019. I spoke to thousands of people, and a lot of typically older men confided in me, I'm afraid now to have coffee with my junior associate, or, I'm worried about getting in a cab with a female colleague. And at first my reaction to that was, well, don't sexually harass them and you don't have a problem. And I was really dismissive of that attitude. I thought it was stupid because there is no evidence that false reporting is a problem. False reporting of incidents occurs in like 0.03% of cases or something like that. It does happen. It does happen. I'm not denying that, but it's incredibly rare. So it should not be the focus. But the more I engaged with people, the more I realized that they had this genuine fear. And that was genuine, even if it was potentially irrational. And what I realized through this journey is that dismissing that fear isn't going to change hearts and minds. It's not going to change behavior. And if anything, people will become more withdrawn, and that will impact mentoring and development, etc. So I think, and this is hard, and I don't have easy answers, but I think we need to engage constructively with the backlash. We need to have open conversations, talk about how things have changed and how things have stayed the same, and have dialogue on these issues. So one workplace I've done some work with, they have introduced reverse mentoring on issues of diversity and inclusion to try and connect, senior members of the profession with new members of the profession to talk about issues of diversity, inclusion, harassment, etc. Now, that's not perfect, and I'm not suggesting that we need the disproportionately targeted members of the profession to be the ones fixing the problem, but I do think we need to engage with the backlash. Final 2 points. Obviously, these issues form part of a much bigger picture. And although, today we've focused on sexual harassment, my work focuses on bullying and harassment, we can't look at these issues in isolation from broader concerns in many professions about mental health and well-being, diversity and inclusion in leadership and throughout, workplace satisfaction, alcohol and drug use is a major problem in the legal profession. And I see this as just pieces of a puzzle. There's no silver bullet to any of these, but if we address all of them, we make progress. I gave a webinar recently, and someone else I thought had a great phrase, which was, you can look, so we've got an elephant on our plate that we need to address, and we can look at it and admire the scale of the problem as long as we want. But at some point, you've just got to start eating. And, that's a slightly poor crass analogy, but I thought it was, to me, it was impactful. We've just got to start. It doesn't matter where we start, we've just got to start. And we will, through time, make change. And so then finally, I really implore everyone on the call, you can make a difference in your workplaces. You can make a really constructive difference in light of your position of influence. But for all of us, we can't let this go. We had the Me Too movement. We've had, just in the last few months, a lot of impetus in Australia. But we've had incidents before, as I said from that American story from the 1980s, there was an outcry at the time. That case in New South Wales in the 80s that I mentioned at the very beginning, there was an outcry at the time. We've had these mini Me Too moments before. We've currently have the benefit of, a lot of social momentum, political momentum on these issues. We've got to make the most of that, and we've got to ensure that maintains. And it's easy to sort of forget about these things already in the legal profession. Reporting around the harassment story around Hayden, etc., has died down. People have moved on. We can't let that happen. We have to continue the momentum to ensure that all of our workplaces are as free as possible from these insidious forms of behaviour. On that note, I will shut up.
Thank you so much, Kieran. That was absolutely great. One of the slides with regards to the wet t-shirt competition in the 80s, that is just a shocker. And we had sad faces coming up in the chat box when that was up. So yeah, I think our audience obviously agree how disgraceful that was. So we've got a few questions that I would like to ask, if that's okay. So first of all, just a question from me really is, how does the legal profession compare to other professions in addressing the issues on sexual harassment? Because obviously all of our audience, they're not all from the legal profession.
Yeah, so I'm often asked, how does law compare? Is law better or worse? I think there's some evidence that law is worse in terms of prevalence. If you look at structural factors that contribute to inappropriate behaviour, it's things like male-dominated senior leadership, very hierarchical profession, very power-based profession. Those things are all true of law to extents that are perhaps greater than other professions. So I think maybe our prevalence statistics are higher than potentially other professions. But as the Human Rights Commission's work has demonstrated, this is a problem everywhere. It's not just a problem in law. Law is beginning to move, and it's being pushed by regulators and by peak bodies such as ours. And so momentum is there and change is occurring. And I've worked with some fantastic organisations that are doing a lot to drive change. But obviously this is a long journey, and we're only just sort of beginning really.
You mentioned earlier on about some recommendations to be put in place. Do you know if they're going to be in 2020 or 2021 or in the future?
So, I mean, I think any workplace can and should start right now. And there's a lot to be done. And I think, some of those examples I gave around, new reporting pathways, engaging staff at all levels to participate. I think like at a really, at a basic level, something you can do tomorrow. We're seeing more and more workplaces conduct anonymous sort of workplace culture surveys around, bullying, harassment, diversity, inclusion, mental health. And that's something you can, roll out tomorrow to your staff on an anonymous basis. I've worked with a number of firms. Our survey came out and they looked at that and they were shocked, but obviously that's macro global, and they took the occasion of our survey to run a similar thing internally. And they said for them, that gave them a lot of momentum internally to drive change, because it's all well and good to see the numbers globally macro, but to know that people in your organization, even if they're only telling you this anonymously, have felt unsafe, felt uncomfortable, have experienced these sort of incidents, I think that can be really, give particularly senior leadership the ammunition to drive change.
Yeah, thank you. Do you know if there's any evidence in statistics that sexual harassment or physical harassment numbers have dropped due to COVID and working from home?
That's a good question. And so I think the answer to it is slightly multifaceted. So there is evidence that reports of sexual harassment, sort of historic behaviour, so things that had occurred pre-lockdown, have increased during lockdown, because people, by working from home, have felt more empowered to speak up about prior experiences. So I know a lot of larger workplaces are experiencing a sort of a flood of historic allegations that are being made. And I think naturally you'd expect, and I don't have data on this, you'd expect that if people aren't in the office, there's less physical incidents occurring, of course. That doesn't mean harassment or bullying are going away. And, I guess it's just shifting to an online forum, and we are seeing that. And even pre-COVID, our report identified incidents of harassment and inappropriate behaviour via messenger and chat, etc. Now, at a really pragmatic perspective, from an employment law perspective, if you're harassing someone over work chat, it's a lot easier for the employer and their lawyers to deal with that, because they've got written evidence. So people who do that are ill-advised. But so although maybe numbers have dropped in this COVID era, I think, we can't let COVID disrupt the momentum on this. And, at some point we'll return to the workplace, or even if we don't in the same sort of style, we're still going to be interacting with colleagues and other stakeholders moving forward. And so we need to sort of address these issues that we know exist. And COVID obviously gives rise to other concerns. I think the last HR Breakfast Club, which I've also done some work on, around domestic violence, much more of a concern when everyone's at home due to COVID. So I think we and some organisations I've been speaking to have said they're trying to use this sort of reset of not being in the office to think about and then to develop strategies they can roll out, taking advantage of this quite unusual sort of break in proceedings. Now, I know in Canberra, things in some places, some workplaces are reasonably back to normal, but doing work in places that there's still, no one's still back in the office, they're really trying to, capitalize on that opportunity, which is so unusual.
Yeah. Okay. No problem. Thank you very much, Kieran. Okay. So can I please thank everybody for joining us this morning? And I really hope you enjoyed the presentation. We will send a summary out, and we will send a link to the US2 report that Kieran did. Our next HR Breakfast Club will be held on Friday, the 16th of October. We have two different wonderful guest speakers for you on the topic of cyber security and privacy in the workplace. Calendar invite will be sent out shortly, or you can RSVP through our website, which is hrbreakfastclub.com.au.